G'day members. I just wanted to provide a brief video update. I thought as a way of communicating with you. As you know, Teys has denied the union access to the site and put unreasonable and in our view unlawful restrictions on our entry. So, and while that matters before the court, we're going to have trouble communicating with you. Now, as you know, Teys around the 16th of September raised that they intended to amend or update their EBA. They put forward at that time that they were intending to meet over a period of the coming 4 weeks, starting on the 21st of September. And really they had a ready-made document for your consideration. We raised some concerns and objections. That is that we were hoping that the meetings could be delayed while appropriate employee representative committees, workplace committees be formed, which included representatives from each work area, as is traditionally the case when we are bargaining with Teys for an enterprise agreement, including on the last EBA. But Teys has just moved ahead with that without really giving that much consideration. They started that first meeting. So as you know, we put those concerns to you as well in a newsletter correspondence. And in that newsletter correspondence, we also asked for your feedback on any claims or concerns that you had with their proposed offer and things that you would like to see in an enterprise agreement. Thank you to those who did provide us that feedback. We use that to form claims. And in addition, we added some union concerns regarding the agreement's interaction between the NES and the meat industry award that we raised with Teys as sole bargaining representative, not an employee of Teys, but a bargaining representative who's discussing the EBA on their behalf. My understanding is he's operating out of Canberra, so these meetings are being conducted via video conferencing. Not an ideal way to conduct such meetings. And in fact, at the last meeting on the 7th of October, there was a lot of trouble hearing the different bargaining parties. And, you know, we made, you know, raise those concerns with the sole bargaining representative. But really what it looks like is that they're not giving this process the serious consideration that it deserves. That's what I'd just note about that. What I thought I would do is that the company late last night, or 7 o'clock last night, provided, they say, the minutes for the last meeting. And while we've got concerns with the way that the company has reflected the discussions, that is, it lacks context and they make omissions to really relevant positions of the union and some of the discussions that were had. So it doesn't really reflect, their minutes don't reflect the discussions in an accurate way. But nonetheless, one thing they have done in providing their last minutes, they have captured the claims that we put forward. And I thought, based on the claims we've put forward and some of their answers that are in their minutes, I can provide you a little bit of additional context. So I'll go to that now. I'm going to share my screen with you, which is the minutes that I refer to. And I just thought I'd run through it. So the first item on the agenda, as I've discussed, we have problems with their minutes. Our problems with the minutes were so extensive that time would have been wasted correcting or trying to correct their minutes. We're not interested in that. We've kept our own minutes at the time that do really reflect those discussions appropriately. But I thought this is a good way today, because the claims are reflected appropriately, for me to give you that bit of extra context. So as I say, thanks for members for their feedback, and we have based the claims on that feedback. Something that people were telling us and have for years now is that they don't feel that they're well represented in any worksite committees anymore. That is, employee elected committees or a JCC, Joint Consultative Committee, with a proper established constitution, with employees electing relevant people from their work areas from across the plant, who have the ability to reach agreement, binding agreement with the employer on ways of working at the site. You don't have that. You don't have that in your enterprise agreement. And the other background factor is that people are concerned about the workloads they're expected to work under, and a way of fixing that was within an agreement process under the Joint Consultative Committee. So we've put forward a claim, a system of claims based on facilitating a Joint Consultative Committee at the site, which, as you'll see in the dot points there, is intended to give a forum for discussion on mutual concern, and that list of other things, but importantly to develop and reach agreement upon production agreements mandating the size and composition of boning teams or slaughtering gangs for production targets and or the specifications as set by the business. Now, the intention there was to have an enforceable body that was set up to be able to reach agreement on these things productively between operational management of the site and workers. And really, Teys has just basically brushed past that claim. Basically, they say that the current Q&A has the ability to do those things. And what I say to you is that it really doesn't. When the company tells you at those forums what's going to happen, there's no obligation on them to make any agreement with you based on any concern that you raise at that forum, which means it really is just a place for them to tell you what they intend to do. So what we were trying to establish on your behalf was a JCC, which had those powers, but the company has rejected that claim. Further, and please do review those claims as they post them on the minutes board, because that is how we raised each of those claims. What we asked for in wages and allowances, the company hasn't appropriately reflected that in the minutes. What we said was that there should be a minimum set wage increase based on two factors: the minimum percentages that we put forward for a 2-year term, that is to not lock an agreement in for 4 years, but that a minimum floor of 2.5% or the Fair Work minimum wage, whichever is greater. And the reason for that is that it has been recognised that low-paid workers in this country aren't getting fair wage rises, and the Fair Work is raising minimum rates by more than, that is by on percentage terms, by more than what people are achieving relative to wage increases in agreements. And what's happening is people are starting to fall behind. And a way of addressing that was to make sure that that minimum percentage that is recognised as what should be the floor, it continues to be passed on to you. And in addition to that, it wasn't that we were seeking those wage rises as a maximum, that's for certain. If the company was going to continue to pass on some higher wage rise that they say is relative from the board. So the way they reflect it, it looks like that's all we were seeking. No, we were seeking those things as a minimum. Bonus eligibility criteria to be included in the EBA. The concern there is that people have no way of knowing whether they're going to achieve a bonus, what specifically they have to do to be eligible to receive that bonus. So the problem there is that bonuses are an incentive. They're really used as a way of getting people to do something that little bit more to try and mutually try and achieve a better result for the company and then achieve a bonus. But if you don't know by set targets how you can achieve that bonus, you apply yourself to trying to achieve it. But then in the end, they say, oh, well, the criteria have changed this year, so you didn't make it. You applied yourself in a way where you thought you were really, and you probably did, help the company's profits, but you never achieved the bonus. And that really seems unfair. And that's the concern, and that's the way we raised it there. But again, the company's rejected it and said it's at their discretion. And that is the problem with it, is that the bonus might as well, not exist when it's completely discretionary. There is no set criteria, and it's a very unfair way of applying it. Overtime or equivalent penalty rate paid after 38 hours. The claim there is that, as you know, you're on a 38-hour week now. Most workers, when they do more work than 38 hours in an ordinary week, are paid overtime. And that was the claim, is that you should be paid overtime when you do more than 38 hours. Recognise that you can do up to 40 ordinary hours, but a penalty rate should be paid for those last 2 hours. That's what we were seeking there. The Saturday additional days just be outright voluntary. Overtime really should be voluntary. We know people have raised concerns with us, although you haven't been doing a lot of Saturdays in recent times. Concerns were raised when the company was doing a lot of Saturdays that people were having, trouble managing a real family life at the same time. If those days were directly voluntary and they were paid appropriately at an appropriate loading, as it is of time and a half for the first 2 hours and double time thereafter, instead of the current rate of time and a half for longer than that, then they'd have no trouble reaching or seeking volunteers. We raised the concern of the afternoon shift attracting a 15% loading as it's relative to the award. I do recognise that the company has raised some of those shift loadings for classifications 5 and 4, etc. Our view of that is that the reason that they're likely to have raised those rates is that at the time of the agreement being tested against the relative award, the award paying a 15% loading for similar or comparative work, some of those classifications which pay or start at a lower base rate, they might have trouble passing the boot test with all of the other flexibilities that they've gained throughout the agreement. Now, the company's done some clever work there and provided a table for you in its minutes that suggest based on a bonus rate. We acknowledge that on those higher levels, that concern is less likely to exist. That is the base rate of pay under the award. When you add appropriate loading against the award, just as they have, there is a significant increase above. The concern we have, though, also is that without quantifiable wage rises, because the company is only intending to pay under CPI, and as everyone knows, CPI is a very volatile measure. It can be zero in a year, but it can widely vary. And the concern there is that there's no quantifiable or obligation on them to pass on any wage increase at all in that circumstance. And the award base rate does increase year on year, usually, and lately it's been by a fair percentage. And what ends up happening is that those base rates during the life of a 4-year agreement could creep up. And when a lesser relative loading is paid, those rates could be exceeded and the company could lawfully be paying less than the award. And we wanted to see a scenario where that doesn't happen. And we don't think that's fair, obviously, but it's a technicality under the law. The only thing they must lawfully pass on to you in an enterprise agreement for the life of that agreement is the minimum base rate of pay. So if the base rate of pay is in excess of that minimum, regardless of other relative percentages, for instance, shift loading of 7.5% while the award pays 15%, or public holiday penalty rates of time and a half where the award pays double time for some of those in addition to ordinary time, so triple time effectively. Those offsets get to be kept by Teys, even though they may not, if you added all of those things together, be earning more than the award. And that's our concern. It's a complex problem, and to address it, we wanted those loadings lifted. But Teys again has rejected that. Our claim on seniority being the determining factor, it's one of the problems when you are regular daily hire that really the company can choose how it stands you down. The idea that it's a whole plant being stood down, I'll give you an example. You could stand one shift down, for instance, and continue to only stand that shift down. because it's cheaper to do so. Now, that's generally not in Teys's interest, but closing loopholes is in people's interest, making sure that an enterprise agreement puts limits on what a company can do. So that's what that claim's really about. They say members want no junior rates to be paid. That doesn't specifically reflect our claim, but it is no junior rates. We don't believe that junior rates should be paid in the agreement, and we got feedback from members that one member in particular that junior rates should be removed from the agreement. It's in the meat industry, it's not common for people to pay junior rates. We say that, you know, once you're doing the job, you're doing the job, and you shouldn't be paid any less for doing that job just because of your age. So that was what that claim was based on. The paid rest breaks, Teys says that paid rest breaks are offset because they compensate you by paying you higher rates, I think was their position there. I'm just going to make sure I can read that properly, sorry. Move my video down there. Yes, so they reflect that the higher base rates. The issue there is that, you know, most sheds in the industry, well, all virtually sheds in the industry pay higher than base rates of the award pay, many well in excess of what are paid at Teys at Beenleigh, that's for sure. And most sheds still do have some paid breaks for all breaks, in fact, but at the very least, the award reflected 10 minutes paid breaks. You don't have that. So that was the claim there. But again, Teys rejects it. Annual leave loading paid on annual leave taken, that including within the first 12 months. The concern there is that a new employee to the site, under the way that the agreement is worded, doesn't get provided access to their 17.5% loading. And the concern there is that employee can be expected to be stood down during the shutdown period, and so directed to take a period of time off and be given access to annual leave during that time. They should achieve the relative loading at that point. And it appears that they've considered that claim if they're not offered alternative work during that shutdown period. So that may address that concern, but we'll review that further. As I say, I only got this at 7 o'clock last night. So, and they didn't give that feedback during the meeting. MISEF Super is the default. The union did put this position forward, and as you know, that MISEF is the union fund. It is one of the best performing funds in the nation, and meat workers generally across Queensland and the nation benefit from other meat workers participating, but also on the basis that MISEF is, as I say, one of the better performing funds. We wanted people to be given that opportunity. Now, Teys says they still do have the choice of fund, and that's true. But the concern is that people get pushed onto a default fund, and we'd prefer that be one of the best performing funds. So Teys has rejected that position on that basis, that they intend to keep AMIEU as the default. Now, reclassification can occur by agreement only. That's a claim based on the company changing or adding a new clause to their proposed agreement, the new clause to reclassify with on performance grounds down to a lower classification. We say that should only be by agreement with the employee. The company rejects that. It says it's in place in other sites, and it's a good way of basically giving people an option to stay even though their performance is poor. And we don't disagree with that. That if the job's not right for people, they should be able to agree, in our view, to go to a lower classification or a more appropriate role. The concern is that this can be done without agreement. Yes, consultation they intend to do and follow a process, but they can enforce that downgrading. And as our big concern there is that, you know, the way that Teys chooses to manage attendance, for instance, and performance, and tie those things together, people should be very alarmed about that. That is, they suggest that there's no disputes on the issue. The problem is when you've got a measure where people know that there's the threat of being downgraded in their employment, and they know the way that Teys, for instance, treats absence and what they call excessive absence, people start being forced to toe the line when really they had a workplace right to be away from work and temporarily ill or injured. And sometimes circumstances in life mean you do end up taking a lot of absences because of a specific event. We know that we have problems with the way that Teys treats people in that regard. So that's a fairly concerning claim. The company says it's not a problem, and so they're going to keep it in. But we know, and that should be one of the reasons that we think you should consider that this isn't a fair deal, and that's a very concerning change. I'll just move along. The public holiday substitution to occur by majority employee agreement. Now, we put that forward. There is a further concern, though, under the Fair Work Act that that doesn't meet the standard that is currently in your agreement. The staff committee, which they now call the Q&A, but the staff committee is what measures or what has the power to change or substitute a public holiday. We say that should be just by actual employee majority agreement. That's the appropriate way to do that. But also there is a concern under the Act, and it's a valid one for, excuse me, for individuals, is that it should be by individual concern also. And we raise that in the context that, for instance, an individual who's very likely sometimes to have trouble on a public holiday where childcare facilities and things might be closed, it's not fair that you expect them to change their public holiday and then not have arrangements in place or have difficulty. So they should have a right to keep the public holiday as it stands. And in fact, the Fair Work Act recognises that. And so while majority agreement is a good way to facilitate and reach a consensus, because you are a whole plant and the shift will either operate or it will not, it should also reflect individual agreement, and that will need to happen actually for the agreement to pass through the Fair Work Commission. So that's really, I think, the only reason they made that change, although it was one of our claims, is because legally they probably have to. Now, they say the next meeting is now scheduled for 2 p.m. Today, that is. I'll provide a further update after that meeting and some feedback. I would suggest from the way that Teys has put forward their meeting schedule, they intended to have 4 meetings. I would suggest they probably intend this to be the last meeting and to close out the issues. This seems to be their response to your log of claims. I don't think they've given any real and genuine consideration to too many of the things that we put forward, and particularly concerning, and I might just stop sharing that screen. Particularly concerning is that they're asking you to sign up to a 4-year deal with no quantifiable wage increase. The company says that they've separated wage increases from the EBA process. And the concern that we'd have there is that why then do they need you to sign up to a further 4-year deal? What is it that they're seeking by locking you into 4 years when they say wage increases are no longer tied to the EBA? Why wouldn't you lock the deal in for 1 year and, as they have in the past, leave that deal operating beyond its nominal expiry? I would suggest to you there must be a motive in locking this deal in for 4 years. And while I don't know that motive, I'm not sure that it's got the employees' interests at heart. So I would suggest to you that locking yourselves in for 4 years with no quantifiable wage increase is not a fair EBA, and I would encourage you to vote no for the EBA. There are ways of addressing that, but the company hasn't genuinely considered it. That is, having reasonable and genuine minimum wage increases like we put forward, and tying those wage increases to the floor of the minimum wage review. That's a further safety net is the best way of putting it. But as I say, the company's not interested in that. So I guess, yeah, you should challenge their motives when they say wage rises aren't tied to the EBA process, but we still want to lock you in for 4 years. Well, why? If you could put us into an agreement for 1 year and have it pass its nominal expiry, as the 2016 agreement has, and continue to pass on wage rises, but make the changes that you are considering now, it really doesn't add up. So people, as I say, don't know the motives, but I'd be very skeptical. So thanks for your time. As I say, after today's meeting, I'll give a further update on where things have gotten to. And please feel free to contact me. My details will be in the SMS as I link this video. And if you have any concerns, I'm very happy to raise them with the company at today's meeting. Thanks very much, and I'll talk to you soon.